My son-in-law sued me over my own ranch. My daughter sat at his table and signed an affidavit against me. For 2 hours I sat alone in silence, listening to their confident lies. Then my lawyer finally walked in, placed one single document on the judge's bench, and they couldn't even finish a sentence. Their betrayal is about to backfire hard. Before continuing, subscribe to the channel and write in the comments what time it is in your region right now. My name is Herbert Wallace. I'm 68 years old, and I live 23 miles east of Lubbock, Texas, on a stretch of land most people would call a ranch, and I call home. For 31 years, I worked as a certified general appraiser, the kind of man who reads a property document the way other men read a novel. Every clause, every footnote, every line that's designed to look unimportant. When I retired 4 years ago, I didn't exactly miss the office, but I kept the habits. You don't spend 3 decades reading fine print without developing a certain kind of patience, the kind that looks like stillness from the outside and feels like coiled wire on the inside. Wallace Creek Ranch covers 340 acres of West Texas, red clay soil, a dry creek bed, a working well, 2 barns, and a greenhouse I built with my own hands the summer I turned 55. That greenhouse is where I grow my peppers, 43 varieties, including Carolina Reaper and Trinidad Moruga Scorpion. I sell hot sauces at the farmer's market on Avenue Q under the name Hellfire Herbert's. People remember it. People come back. I'm not a dramatic person. I don't raise my voice. I don't make threats. I do, however, remember everything, and I keep very good records. My daughter Christine is 39 years old. She has her mother's eyes and, for a long stretch of her life, her mother's good sense. When she was small, she used to follow me through the greenhouse rows on Saturday mornings, asking the name of every plant in a voice that suggested the answer mattered enormously. I'd tell her, she'd repeat it back, perfectly, and nod like she was filing it away. Smart girl, careful girl, the kind of person who looks before she steps. She married Devin Howell 6 years ago. He was 32 then, smooth in the way that some men are. Not polished exactly, but frictionless. The kind of man who enters a room and immediately understands which direction the social current is running. He works in real estate, a senior agent at Lubbock Realty Partners. When he first shook my hand, his grip was firm and his smile was wide and his eyes were doing something different from his mouth. I noticed. I told myself it wasn't my business. For the first 2 years, I told myself that regularly. Devin and Christine live at 4812 Juniper Avenue in Lubbock, a 3-bedroom house that I suspect feels to Devin like a waiting room. He has a talent for communicating dissatisfaction without ever stating it directly, a certain way of glancing around a room before settling, like he's calculating the gap between where he is and where he intends to be. I watched him do it at family dinners, at Christine's birthday, even standing on the porch of Wallace Creek looking out at my land. There it is, I'd think. There's what he's calculating. The change in Christine happened slowly enough that I could have missed it if I hadn't been paying attention. It started small. She'd repeat something Devin had said about the ranch, as though she'd arrived at the thought herself. Then came his particular word for what I'd built. Frozen capital. Like 340 acres of Texas soil, and 30 years of my life were a financial instrument that hadn't been optimized properly. I let it go. But there's a difference between letting something go and not seeing it. It was a Sunday in early spring when Devin finally decided to have the conversation he'd been building toward for years. Christine was in the kitchen. He and I were sitting on the back porch with coffee going cold between us, looking at the land, and he started talking about the future. Their future. How real estate in Lubbock County was moving. How a property like Wallace Creek would sell for well over $1 million in the current market. How it seemed a shame for all that value to sit untouched, when it could become something for the whole family. I listened. I am a patient man. Then he said it plainly. He thought I should voluntarily transfer the ranch into joint marital property, his and Christine's, so that the family could, as he put it, build a shared future together. I sat with that for 2 seconds. Just 2. Then I said, Devin, the ranch isn't a restaurant menu. You don't get to come in and choose what you want off it. He laughed. It was a good laugh. Practiced. Easy. the kind that's designed to make the other person feel like the tension was all in their head. His eyes did not laugh at all. "Herbert," he said, "I'm just thinking about what's practical." "Practical," I said, "is a word people use when they want something that isn't theirs." He stopped talking after that, and we finished our coffee without another word. Christine came out 15 minutes later, and the three of us had dinner, and nobody mentioned it again. Devin was pleasant all evening. He helped clear the table. He complimented the pepper sauce I'd put out. I watched him the whole time, the way you watch a pressure gauge when you're not sure about the line. After dinner, when Christine was washing up, Devin wandered back to my study. "Just browsing," he said, looking at the books. I was in the hallway when I heard the particular silence that means a person has stopped moving. I stepped to the doorway and saw him standing at my desk with his phone out and the screen facing down at the papers I'd left there. He was photographing my documents. He didn't know I was there. He flipped to the next page, took another photo, slid the phone into his pocket. Calm as weather. Then he picked up a book from the shelf and turned around, and I was gone before he saw me. I walked to the greenhouse. I stood between the rows of Carolina Reaper in the dark, and I thought about what I had just seen. Not what it meant. I already knew what it meant. I thought about what came next. The peppers didn't have anything to say about it, but they never do. They just grow. I have a filing system that Devin did not fully appreciate when he was photographing my documents. Organized by date, category, cross-reference. 30 years of professional habit. Every document I ever signed has a folder. Every folder has a number. Every number is logged in a ledger in the second drawer of my desk. Not the drawer that was open when I caught him. The week after Devin's visit, I walked into the study on a Tuesday morning to pull a maintenance receipt and stopped in the doorway. Something was different. It took me 11 seconds to identify it. I counted because that's the kind of person I am. The archive cabinet in the corner had its third drawer, sitting a quarter-inch further out than I leave it. I always push it flush. I crossed the room and opened the drawer. The folders were in order, but the order was wrong in the way that only matters if you put them there yourself. Someone had pulled a file, looked at it, and replaced it. Carefully, but not carefully enough. The file was from 1998, a promissory note for $18,000, signed by my brother, Lenny Wallace, who passed away 4 years ago. He'd borrowed the money from me against a small piece of property he owned, a proper legal document, properly signed but never formally discharged. When Lenny died, the debt became one of those things that family absorbs. I sat down and looked at the document for a long time. I thought about Lenny. He was 10 years younger than me and had our father's laugh. Big, unpredictable, coming from somewhere in his chest. He taught Christine how to whistle when she was 5. When he died, she cried for 3 days. And now someone had photographed this document. Photographed it, come back when I wasn't home, and studied it long enough to understand what it might be worth to them. That someone was standing in my kitchen 4 days later, drinking my coffee and telling Christine that everything was fine, that they just wanted what was best for the family. I called Devin's number the morning after I found the displaced folder. He answered on the second ring. Easy voice. Frictionless hello. I asked if he'd been by the house while I was in Lubbock picking up greenhouse supplies 2 days before. He said no, of course not. I said no reason, just thought Christine mentioned something. He said Christine was right here. Did I want to talk to her? I said no, that was fine. I hung up and called Dexter Morris. Dexter Morris is 55 years old and works out of the 5th floor of the City Plaza building in downtown Lubbock. He specializes in real estate law. He is not warm, not particularly friendly, and reliably 15 minutes late to everything. What he is, without question, is thorough. When I told him what I'd found and what I suspected, he was quiet, the particular quiet of a man running calculations. And then he said, "Herbert, do you still have the original promissory note?" I told him it was in the folder where it had always been. "Keep it there," he said. "Don't move it. Let me think." 3 days later, an envelope arrived at Wallace Creek from a law firm in Lubbock I didn't recognize. Inside was a 2-page letter laying out a potential claim against my assets based on the 1998 promissory note, suggesting that the outstanding debt created grounds to seek partial control of assets connected to it, Careful language, patient language, the kind someone uses when they've had a professional help them find the right words. I read it twice. Then I set it on the kitchen table and poured myself a cup of coffee. I thought about Christine at age 11, standing in the greenhouse on a July morning with soil on her knees and a seedling in both hands, asking me why some plants grow better when you leave them alone. I told her it wasn't that they grew better. It was that some things need space to develop their own strength. You can't rush the process. Push too hard, too early, and you get something that looks like growth but breaks the first time the weather changes. She nodded and planted the seedling carefully. Where did that girl go? I don't think she went anywhere. I think she's still there, underneath. But something had been growing over her for years. Something that spoke in a calm voice about practical matters and shared futures and frozen capital. She had tended to it without fully understanding what she was growing. Her call came that evening. She used the voice she uses when she's delivering a message someone else prepared. Measured, slightly too steady. She said things had gotten complicated, that Devin had consulted a lawyer, and that maybe the simplest path was for me to sign a transfer of partial interest in the ranch to them. It's not about the money, Dad. It's about stability, about us all being in this together. I said, Christine, who wrote that speech? 4 seconds of silence. Then she said I was being unfair. I told her I loved her. I told her I'd think about it. Then I walked out to the greenhouse. The Trinidad Moruga scorpion plants were coming in strong that season. They require a long growing period, stubborn, slow, producing nothing visible for weeks before delivering something that will make your eyes water. I stood in the row and looked at them in the last evening light. Then I went inside and found a business card from the Lubbock County Appraisers Conference 3 years back. Randall Taylor, private investigator, Amarillo, Texas. Filed, numbered, cross-referenced. I picked up my phone and dialed. Randall answered on the third ring. I told him I had a job, a real estate agent, a document trail, and the specific variety of patience required when you already know the ending but need to build the path to it properly. He said he'd drive down in the morning. I said, Good. And Randall, bring your reading glasses. We're going to be looking at a lot of paperwork. Randall Taylor drove down from Amarillo the next morning in a gray pickup that had seen better decades. He was a compact man in his late 40s, with a beard that suggested he'd stopped caring what barbers thought of him, and eyes that moved around a room the way mine move around a property. Cataloging, measuring, not missing much. We met at a diner off Highway 84, 40 miles west of Lubbock, because I didn't want us seen together any closer to home. He ordered coffee and eggs. I ordered coffee. He pulled out a small spiral notebook. What kind of job? He said. Due diligence on a real estate agent? I want to know what he's filed, what he's closed, what complaints have been lodged against his license, and whether his finances are as healthy as his smile suggests. Name? Devin Howell, senior agent at Lubbock Realty Partners. He looked up briefly. Relation? Son-in-law? He nodded once and went back to writing. He didn't ask why I wanted the information, which I respected. We agreed on $4,800 for 1 month's work, with a written report at the 2-week mark and a final summary at the end. I wrote him a check, and he folded it into the notebook without looking at the amount. When I got back to the ranch that afternoon, there was a message from Dexter Morris. I called him back from the porch, watching the late morning light move across the pasture. The lawsuit is official, Dexter said. He did not sound troubled, which I'd come to understand was how he sounded when he was paying close attention. Filed this morning, Howell is claiming the 1998 promissory note represents a financial instrument from which subsequent assets, specifically Wallace Creek Ranch, can be traced. He's arguing partial constructive interest based on an unsatisfied debt. The amount? They're seeking $310,000, equivalent to roughly 25% of the assessed value at the time of the last formal appraisal. I was quiet for a moment. $310,000? Devin had done his math carefully, not greedy enough to seem unreasonable, not modest enough to be dismissed. The number had a professional quality to it. Someone had advised him well. What's your read? I asked. Aggressive and not without creativity, Dexter said. but it requires the court to accept several assumptions that I'm not prepared to let pass unchallenged, the central one being that the note was never satisfied. It was satisfied, I said. A pause. When? October of 1999. Notarized. Filed with the county recorder's office. I have the original. Dexter was quiet for 4 seconds. When he spoke again, his voice had shifted. Not warmer exactly, but more precise. The way a man sounds when a calculation resolves cleanly. Herbert, don't touch that document. Don't copy it. Don't discuss it with anyone. I'll come to the ranch Thursday morning. I agreed and hung up. Then I drove into Lubbock to the county recorder's office. Aileen Burns worked on the second floor, a small, deliberate woman in her early 60s, who had notarized a great many documents for me over the years and operated with the precision of someone who understood that a stamp placed incorrectly could unravel a family's finances. Decades later, she looked up when I came in. Herbert Wallace, it's been a while. I need a certified copy of a notarized record from 1999. Satisfaction of debt, executed in October, she typed without asking further questions. The certified copy came back in 11 minutes. I signed for it and drove back to the ranch. Dexter arrived Thursday morning at 8:45. He sat at my kitchen table with both documents in front of him and read each one twice. Then he looked at me. Devin Howell built his entire lawsuit on a debt that no longer exists, he said. He built it on a document he photographed in my study, without knowing there was a second document in a different drawer. I'll prepare the response filing and a procedural counter-motion to slow their timeline. It won't stop them, but it'll cost them weeks, he paused. Anything else I should know about? Wait for Randall Taylor's report, about 10 days. He wrote down the name without asking who Randall was. 9 days later, Randall's preliminary report arrived by email. 6 pages, with a 2-line summary at the top. Subject has 3 open complaints filed with the Texas Real Estate Commission. Details follow. I printed it and sat down with a cup of coffee that went cold while I read. The complaints were real, specific, and sourced. 2 buyers, 1 seller. All 3 involving either incomplete disclosure or misrepresented property conditions. The most serious concerned a house on the south side of Lubbock, a 3-bedroom property Devin had listed and sold without disclosing documented water intrusion in the basement. The buyers had filed the complaint 14 months ago. TREC had opened a formal inquiry. The case was still active. I set the report down and looked out the kitchen window at the greenhouse. Devin Howell had spent the past several months building a legal case against me using a document he didn't fully understand, while managing 3 regulatory complaints against his own license that he apparently believed no one in my corner of the world knew about. He had come to my ranch, photographed my papers, sent lawyers to my door, and remained confident that he was dealing with a 68-year-old retired appraiser with a pepper hobby and no appetite for a fight. That was the miscalculation, not the legal strategy, the appraisal of the man. He had looked at me the way a careless buyer looks at a property. He saw what he wanted to see and stopped reading. He hadn't checked the second drawer. Dexter filed the counter motion the following week. It was procedural, a challenge to the evidentiary basis of the claim, combined with a request for additional time to prepare a full defense. Nothing dramatic, the legal equivalent of calmly pulling out a chair and sitting down at a table where the other side had expected you to stay standing. I learned the details over the phone on a Wednesday morning while repotting a flat of Agi Amarillo, seedlings, in the greenhouse. Dexter walked me through the motion in the tone a mechanic uses, describing what he found under the hood. Factual, slightly bored, completely in control. Their timeline was built around a 6-week resolution, he said. That's gone. We're looking at 4 months minimum before a hearing date. Good, I said. It'll cost them more in legal fees the longer it runs. Their attorney isn't cheap. Neither are you, I said. He paused. No, he said. I'm not. Then he hung up. 4 months. I could work with 4 months. 2 days later, I drove into Lubbock and spent the morning at the County Appraisal District office on Broadway, pulling public records on Wallace Creek's assessed history. A habit from 3 decades of professional work. Before you defend a property, you know it better than the person challenging it. Every assessment, Every acreage correction, every lien and discharge, everything was clean. It had always been clean. But having it confirmed in writing felt useful. While I was there, I requested a formal independent appraisal through standard process, using a licensed appraiser I had no professional relationship with, a woman named Della Garrett, whose name appeared on 3 recent commercial appraisals in the county records. I scheduled her for the following Thursday. Della arrived exactly on time and spent 4 hours walking every acre, examining both barns, testing the well, photographing the greenhouse. She asked me 3 questions the entire visit, all practical. 10 business days later, the written report arrived, $1,380,000. The market had moved since Devon's lawyers used the older assessed value in their filing. His claim of $310,000, roughly a quarter of the property at the time of the old appraisal, now represented less than 23% of current value. A small difference mathematically. Legally, it meant the claim was built on outdated numbers, which gave Dexter another angle to work with. He called it a useful data point. Coming from Dexter Morris, that was approximately equivalent to a standing ovation. Randall's full report arrived on a Friday, 28 days after our meeting off Highway 84. 11 pages. I read it at the kitchen table with pencil in hand, marking anything requiring follow-up. The picture that emerged was of a man running faster than his foundation could support. Devon had closed 18 transactions over the past 2 years. 3 had generated complaints. 2 were still under active TREC review. The water intrusion case had reached a formal disciplinary stage, an investigator already assigned. Beyond the complaints, Randall had traced Devon's personal finances through public records. There was a promissory note, Devon's own this time, made out to a business partner named Craig Simmons. $47,000 signed 8 months ago, due within the year. No extensions filed, no payments recorded. Devon needed money before the end of the year. That was why the lawsuit had been filed now, why the lawyers moved so quickly, why Christine called me with that prepared speech about stability and shared futures. The timeline wasn't fundamentally about the ranch. It was about a debt coming due and a man who had decided my land was the fastest solution. I sat with that information for a while. Then I went out to the greenhouse, not to work, just to stand in it. The Carolina Reapers were about 8 weeks from harvest. The Trinidad Moruga Scorpions were already yielding their second round. The unnamed cross I'd been developing for 3 seasons was showing the color I'd worked toward. Deep burnished red, darkening almost to black at the stem. A pepper doesn't adjust its timeline because someone else is in a hurry. It matures when it's ready, and if you try to force the process, you get something that looks finished, but isn't. I stayed 20 minutes. When I came back inside, I called Dexter and asked him one question. If a property is held in a revocable living trust, and a civil claim is filed against the grantor personally, what are the procedural steps required before that property can be attached? Dexter was quiet for a moment. That's a very specific question, Herbert. I tend to ask specific questions. I'll have an answer for you by Monday. He hung up. That evening, Christine's car turned into the ranch road just before dusk. She came alone. She had the careful posture of someone who has rehearsed what she intends to say, but isn't entirely sure it will land right. She stood on the porch. Devon doesn't know I'm here. Come in. I'll make coffee. We sat at the kitchen table. She told me, in the roundabout way that was more honest than she realized, that she was starting to feel like she was standing on ground that was shifting under her feet. She was asking, without asking, whether there was something she didn't know. I told her the ranch was fine. That was all I said, and it was the truth. She looked at me a long moment. Then, Dad, the court will sort it out. Her voice was steady. Her hands wrapped around the mug were not. She stood, thanked me for the coffee, and walked back to her car without looking at the greenhouse. I watched her drive away down County Road, 1,700. Then I went inside, opened Randall's report to the page with Craig Simmons' name at the top, and thought about what Dexter Morris was going to tell me on Monday, and what I was going to do with it. Dexter Morris called me on a Monday morning, as promised. I was in the greenhouse checking the moisture levels on the Aji Amarillo flat when my phone rang. I set down the watering can and answered. To answer your question from last week, he said without preamble, Dexter never wasted time on greetings. A revocable living trust in Texas does not, in itself, shield property from a pre-existing civil claim. However, it substantially complicates the procedural path to attachment. The claimant would need to demonstrate that the trust was created specifically to defraud a known creditor, which requires proving fraudulent intent. That's a higher bar than a simple lien. What if the trust was established before the lawsuit was filed? Even better, if the trust predates the claim, the fraudulent transfer argument weakens considerably. A pause. Are you thinking about establishing one? I'm thinking about a lot of things, I said. I'll have the paperwork drafted by Thursday. I won't pretend it was a complicated decision. I'd been meaning to set up a proper trust structure for Wallace Creek for several years. It was the kind of estate planning that sensible people do in their 60s, and that I had delayed the way sensible people sometimes delay sensible things. Devin Howell had simply accelerated my timeline. If he wanted to spend his lawyer's time and his borrowed money arguing that a legally sound trust arrangement was fraudulent, he was welcome to try. Dexter came to the ranch that Thursday 17 minutes late, with a folder containing a draft revocable living trust agreement for Herbert N. Wallace as both grantor and trustee, with Wallace Creek Ranch and all associated property formally transferred into the trust. He set it on the kitchen table and opened it to the first page without ceremony. I read it twice, the way I read every document, front to back, then back to front, which sounds eccentric until you've spent a career finding the sentences that matter, hiding in the second-to-last paragraph. I found 2 clauses I wanted adjusted: language about successor trustee authority that was broader than I needed, and a provision about trust modification that I wanted to require written notice rather than oral instruction. Dexter made the notes without argument. He came back 2 days later with the revised draft. I read it once, found it correct, and signed it at the kitchen table while my coffee went cold. Aileen Burns drove out to the ranch to notarize it, which I appreciated. She had come to me rather than making me come to her, and she stamped the document with the same precise efficiency she brought to everything. "You're all set, Herbert," she said, and drove back to Lubbock. The deed of trust, transferring Wallace Creek into the Wallace Creek Revocable Living Trust, was recorded at the county clerk's office the following morning. I held the confirmation copy in my hand for a moment before filing it. 340 acres, properly housed. 30 years of work, properly protected. Devin's lawyers found out about the trust within the week. I know this because Dexter called me on a Friday afternoon. Calling on a Friday afternoon was his version of urgency, and told me that opposing counsel had filed an emergency motion alleging fraudulent transfer under the Texas Uniform Fraudulent Transfer Act. "They're arguing you created the trust to shield assets from their claim," Dexter said. "The trust was established after the lawsuit was filed," I said. "Can they make that argument?" "They can make any argument they like. Making it convincingly is a different matter. The fraudulent transfer statute requires proof of actual intent to defraud a known creditor, or proof that you were insolvent at the time of transfer. You are not insolvent. An intent is difficult to prove in a man who simply did his estate planning." He paused. "Carefully?" "Carefully," I agreed. There was a particular satisfaction in hearing Dexter Morris say carefully with that emphasis. He was not a man who used emphasis lightly. The word sat in the air between us like a period at the end of a long sentence. I hung up and went out to the porch. The sun was dropping toward the horizon, doing what the Texas sun always does in late afternoon, turning the whole sky a shade of orange you can't describe, to anyone who hasn't seen it, stretched out flat over West Texas land. The pasture was quiet. The far barn cast a long shadow across the dry grass. Devin was accelerating. I'd expected this. The fraudulent transfer motion was the move of a man who is watching his original plan lose structural integrity and is reaching for anything that might hold weight. But reaching in a hurry means you grab without checking what you're grabbing. His lawyers had filed the motion quickly. What they hadn't done, as far as I could tell, was examine the timing carefully enough. The trust had been executed and notarized on a Thursday. The county recording was dated Friday morning. The fraudulent transfer motion was filed the following Friday. What the motion failed to account for, and what Dexter noticed immediately when I gave him the service records, was that the lawsuit itself, while officially filed, had not yet been served on me at the time the trust was executed. Under Texas civil procedure, a lawsuit exists when filed, but a defendant's legal obligations attach upon proper service. I had been formally served 3 days after the trust was already recorded. It was a narrow gap. But in my experience, narrow gaps are often the most consequential ones. A property can be worth $1 million more or less, based on a survey line that moves 8 inches in either direction. The gap that matters is rarely the large one. It's the one that looks small enough to overlook. I poured myself a glass of water and said, to no one in particular, "The boy is in a rush, and a man in a rush only reads the first line." He was quiet for 6 seconds, longer than usual. Then, "Herbert, where did you get a copy of the service records?" "Randall Taylor," I said. "He's thorough." Another pause. "I'll need to verify this independently. But if the dates hold, their fraudulent transfer motion has a significant procedural problem." He paused again. "I'll call you Monday." I said, "Take your time." Randall's final report had arrived 2 days earlier, 11 pages, complete with source documentation. The $47,000 promissory note to Craig Simmons, Devon's business partner at Lubbock Realty Partners, was due within 60 days of the report date. Simmons had made one written request for payment, documented through public filings. There had been no response from Devon, the kind of silence that has a specific meaning between business partners, not the silence of someone managing a situation, but the silence of someone hoping the situation will somehow manage itself. I sat with that for a moment. I thought about Devon at my kitchen table, talking about shared futures with that practiced smile. I thought about him in my study with his phone camera pointed at my documents, calm and certain, sure that he was the one doing the reading. He had found the promissory note and stopped. He had looked at the first document and decided he understood the story. He had not checked the second drawer. I had the trust, properly executed and recorded. I had the satisfaction of debt in folder number 47 in the archive cabinet, dated October 1999, notarized by Aileen Burns, recorded in the county files. I had Randall's complete report on Devon's 3 TREC complaints and his outstanding debt to Simmons. I had Della Garrett's appraisal at $1,380,000 and Dexter's counter motion already on file. The hearing was set for 6 weeks out. 6 weeks is a long time when you're in a hurry. When you're patient, it is exactly enough. The morning of the hearing, I woke at 5:30, the way I always wake, without an alarm because I trained myself out of needing one a long time ago. I made coffee, I fed the chickens, I walked through the greenhouse once, not to do anything in particular, just to move through it. The Carolina Reapers were coming in well. The unnamed cross was holding its color. I put on the gray suit I keep for occasions that require one. I drove the 23 miles into Lubbock on County Road 1700 with the windows down, because the morning air in West Texas in that season has a particular quality. Dry and cool and honest, and I wanted it in the cab with me. The Lubbock County Courthouse sits on Broadway, a flat rectangular building that looks, from the outside, exactly like what it is, a place where things get settled. I parked on the street and walked in 45 minutes before the scheduled time. I went through security, found the correct room on the 3rd floor, and sat down at the respondent's table alone. Dexter had confirmed by phone the previous afternoon that he would be there. He had also said, "I'll be there," in a tone that did not address the question of when there would arrive. I had made my peace with this. The room filled in stages. Devon's legal team arrived first, 2 attorneys from the firm that had sent the original warning letter, both in dark suits, both carrying leather document cases with the practiced confidence of people who are paid to look unworried. Devon himself came in behind them. He was dressed carefully. Jacket, pressed shirt, no tie, which I recognized as a deliberate choice, the kind of studied casualness that says I am confident enough not to try too hard. He scanned the room as he entered, found me sitting alone at the respondent's table, and his expression shifted for just a fraction of a second. Something moved behind his eyes. Not concern, not yet. More like recalibration. Then Christine came in. She was behind Devon slightly, the way she had been walking behind him for years without seeming to notice it. She was wearing a blue blouse I recognized. I had been with her when she bought it, 3 years ago, at a shop on 34th Street in Lubbock, on a Saturday afternoon when we had gone to lunch and wandered through the stores without any particular purpose. She had held it up and asked what I thought. I told her it suited her. It still did. She looked older than she had that afternoon, not in years, in weight, the kind that settles on a person who has been making decisions they can't fully justify. She sat at Devon's table and arranged her hands flat on the surface, fingers pressed down, the posture of someone trying to appear composed by pressing against something solid. She did not look at me. I looked at her for a moment. Then I looked at the wall ahead and set my folder on the table. The folder from the ranch, with one document inside that I had not opened since placing it there that morning. The judge was a compact man in his 60s, who moved through the pre-hearing formalities the way an experienced mechanic moves through a checklist. No wasted motion, no performed authority. He didn't need to perform it. Devon's lead attorney, a man named Graves, according to the paperwork Dexter had given me, opened the case with the measured confidence of someone who has rehearsed the opening statement enough times to feel like the outcome is already determined. He laid it out clearly. The 1998 promissory note, $18,000, extended to Leonard Wallace by Herbert Wallace, never formally discharged, a long-standing obligation from which, Graves argued, assets had been built and retained. He used the phrase constructive trust with the comfort of someone who has used it many times before, and the phrase unjust enrichment twice more, and each time he used them he built a small increment of apparent legitimacy around the claim, the way a person builds a structure from inadequate materials. It looks like something until you check the foundation. Then he produced the affidavit. The judge read it aloud in the flat procedural tone courts use for documents, a tone that strips everything human out of words and leaves only their legal weight. Christine Howell, née Wallace, stated under sworn oath that her father, Herbert Norman Wallace, had made an oral promise in the spring of a prior year to transfer a partial ownership interest in Wallace Creek Ranch to herself and her husband. She had been present during this conversation. She had heard the promise directly. She was prepared to testify to its contents. I sat still. My hands were in my lap. I thought about that supposed spring conversation, what I had said to Christine, whether anything in that season could honestly be described as a promise to transfer a portion of my land. I have a good memory. No such conversation had occurred. Christine knew that. The only question was what she had convinced herself of in the months between then and now. Devon's second attorney gave a supporting presentation on the trust timing, arguing that the execution date fell close enough to the filing to raise fraudulent transfer concerns regardless of the service date distinction. He spoke for 20 minutes with care. His argument was not without logic. It was simply built on a gap that he did not know existed. That's the thing about people who plan in a hurry. They practice their confident face for the moment they expect, not for the moment they don't. Graves wrapped up the combined presentation just past the 2-hour mark. Clean, practiced. The kind of conclusion you rehearse until it sounds effortless. The judge made a brief note and looked toward the respondent's table. "Is counsel for the respondent present?" I said. "He'll be here shortly, Your Honor." My voice was steady. It was the first time I had spoken in 2 hours. Devon glanced over. His expression was controlled, but I caught the small tightening along his jaw, the look of a man who has just realized that the seat next to his opponent is still empty and is deciding whether that's a gift or a sign. His second attorney leaned in and said something quiet. Devon's eyes moved to the empty chair, then back to Graves. Something in his posture shifted. Not collapse, not panic, just the small, involuntary adjustment of a man recalibrating what he's looking at. To someone who has planned carefully and executed quickly, an empty chair on the other side looks like early victory. Graves was beginning a supplementary remark, filling time, confident idle of a prepared engine, when the courtroom door opened. Dexter Morris walked in. Dark suit, battered briefcase, the particular unhurried pace that suggested he was not late, so much as operating on a different understanding of what time means. He crossed the room to the respondent's table, set his briefcase down without rushing, opened it, and removed one document. He walked to the judge's table and placed it there without a word. Then he sat down beside me, folded his hands on the table, and looked forward. Graves had stopped mid-sentence. His co-counsel had leaned slightly forward, eyes on the document. Devin had uncrossed his legs and was sitting upright now, both feet flat on the floor, the unconscious posture of a man whose body has registered something before his mind has caught up. The relaxed jaw, the still hands, the crossed-leg confidence, all of it had quietly rearranged itself into something more careful. The judge looked at the document. The room went quiet, in the way that rooms go quiet when something has entered that everyone can feel but no one has named yet. He read. His expression did not change. He turned to the second page. He read that too. I kept my eyes on the wall directly ahead of me and waited. The judge read for 30 seconds. In a courtroom, 30 seconds of silence has a different weight than 30 seconds anywhere else. Outside, 30 seconds is the time it takes to pour a cup of coffee. In that room, it was long enough for 3 people to understand that something had changed, and for at least one of them to begin calculating what that meant. Graves, Devin's lead attorney, started to speak. He had the smooth, reflexive quality of a man who fills silence by professional instinct, the way a musician covers a missed note by playing the next one louder. He said, "Your Honor, if I may." The judge raised one hand without looking up from the document. He kept reading. Graves stopped. He folded his hands on the table in front of him and waited. And in the waiting, his composure began to do something interesting. It held, technically, but it held the way a piece of timber holds when you're standing on it over water. Still, but you can feel the flex. Beside him, Devin had gone still in a different way, not controlled still. Stopped still. The kind of stillness that isn't a choice. The judge set the document down. He looked at Dexter Morris. "This is a satisfaction of debt," he said. "Executed in October of 1999. Notarized and filed with the Lubbock County Clerk's office, pertaining to the same promissory note that forms the basis of the claimant's case." Dexter said, "That is correct, Your Honor." The judge looked at Graves. "Counselor, the foundational claim in this action is an unsatisfied debt of $18,000, identified by the 1998 promissory note between Herbert Norman Wallace and Leonard Wallace. Are you aware of this satisfaction document?" Graves had the grace not to pretend. "We were not, Your Honor." "Were you not, or were you not presented with it during discovery?" A pause. "We were not presented with it." The judge turned to Dexter. "How long has your client been in possession of this document?" "Since it was executed, Your Honor. October 1999. It has been in his personal archive continuously." The judge looked at the document one more time, turned it over, examined the notarization stamp on the back. He set it down with the flat finality of a man who has made his assessment. The primary claim in this action rests on the existence of an unresolved financial obligation. This document demonstrates that the obligation was satisfied in full 26 years ago, notarized and recorded through proper county channels. Without a valid underlying debt, the constructive trust theory fails at its foundation. He looked toward the claimant's table. "Counselor, I'm prepared to hear any response you have to this document's authenticity or chain of custody." Graves opened his mouth. What he had prepared, the arguments, the framing, the careful sequence of a case built over 6 months, was structured around a debt that had ceased to exist in 1999. He said, "We would request time to review the document and consult with our client." Devin was leaning forward, elbows on the table, both hands pressed together in front of his face. His eyes were fixed on the satisfaction of debt on the judge's table, the way a person stares at something hoping it will change. It wouldn't. I knew what it said. I had read it many times. The judge said, 15-minute recess. When we resume, the claimant will indicate whether they intend to withdraw the claim or proceed with a revised argument." The gavel came down. Devin stood up fast and pulled Graves toward the corner by the elbow. I heard his voice, not words, but register. Tight, rising, the sound of a man watching 6 months of work develop a crack from foundation to roof in under a minute. Dexter leaned toward me. When we resume, say only what I tell you to say. I was going to say one sentence, I said. What sentence? I told him. He was quiet for 2 seconds. That works. The recess lasted 12 minutes. When Graves returned, he had the composed, slightly depleted look of a man who has spent the interval managing someone else's panic. He addressed the judge. Your Honor, given the document presented by the respondent, the claimant acknowledges that the foundational basis of the primary claim is no longer supportable. The claimant withdraws the main action. The judge nodded. Does the respondent wish to address the court? I said, just one thing, Your Honor. I looked at the judge, not at Devin, not at Graves, not at Christine, who had not moved since the recess began, her hands still flat on the table surface. A debt that never existed cannot be the foundation of any claim. The claim is dismissed. The court will address the outstanding fraudulent transfer motion in a separate filing. We're adjourned. I stood and picked up my folder. Dexter was already closing his briefcase. Behind me I heard chairs, papers, the controlled quiet that follows the kind of loss that happens in front of witnesses. I looked at Christine on my way out. She hadn't stood yet. Her hands were pressed flat against the table, and she was looking at them. Not at Devin, not at Graves, not at the document on the judge's table. Just at her own hands. She did not look up as I passed. I walked out into the morning air and stood on the courthouse steps. The West Texas sky was wide and flat and blue, the way it gets when the light has fully arrived and there's nothing to complicate it. I drove home. I checked the Carolina Reapers. I made coffee and sat on the porch. The ranch was still here. 3 days later, Dexter called to tell me the fraudulent transfer motion had been formally withdrawn. Without the underlying claim to support it, there was nothing left for it to do. The lawsuit was finished. What remained were the other matters, the ones Devin didn't know I'd been building. I called Randall Taylor. The court case is done. The material on the TREC complaints. I want to move on that. Ready, he said. Clean copies of all 3 complaint files. Documented. Sourced. Send them tomorrow. The following morning I drove to Dexter's office on the 5th floor of the City Plaza building, arriving early, which I knew would unsettle him in a way no other greeting could. He looked up from his desk with the expression of a man confronted by something unexpected on a Tuesday. I put Randall's file in front of him and explained. I was not Devin's victim in the TREC matter, not directly. But I was a property owner who had purchased a small parcel adjacent to Wallace Creek 5 years earlier through Lubbock Realty Partners, in a transaction where Devin served as the listing agent. There had been a recorded agricultural easement on the eastern boundary of the parcel, affecting access to a shared fence line. Devin had not disclosed it. I discovered it 2 months after closing through a survey I'd commissioned on my own, because I always commission surveys. I had noted it, filed the information, and moved on. I hadn't filed a complaint because I didn't need to then. Now I did. Dexter read through the file without comment. When he finished, "You have standing. The easement was a material fact that affected the utility of the parcel. Combined with the other 2 complainants, this establishes a pattern of conduct." "That's the point," I said. I signed the TREC complaint form that afternoon. Dexter filed it the following week with a formal referral letter, directing TREC's attention to all 3 cases jointly. TREC responds differently to patterns than to single incidents. A single complaint is an oversight. 3 complaints from 3 separate transactions with a documented referral from a licensed attorney describe something else. Within 2 weeks, I received a standard confirmation letter from TREC. An investigator had been assigned to review all 3 cases. I read it and filed it under T. Craig Simmons, Devin's business partner at Lubbock Realty Partners, the man holding the $47,000 promissory note. Found out about the dismissed lawsuit the same week it ended. Lubbock is a small professional world, and courthouse records are public, and people owed significant money with no payment response tend to keep their eyes open. Randall told me Simmons had retained a civil attorney within a week of the court date. Devin was now managing a TREC investigation on 3 counts and a civil debt action from a business partner. With no active income from the lawsuit, he'd spent 6 months and considerable legal fees pursuing. I thought briefly about what that felt like from where he was standing. I did not dwell on it. The promissory note was always going to fail once someone checked the archive. The TREC complaints existed before I ever involved myself in them. Craig Simmons' patience had its own timeline, separate from mine. Some things unfold when you stop standing in front of them. I drove back to Wallace Creek that afternoon and spent an hour in the greenhouse. The Carolina Reapers were at full yield. I harvested a flat of them, careful with the gloves. Carolina Reaper oil gets into skin regardless, and I had learned over the years that some discomforts are not worth being casual about. While I worked, I thought about the architecture of what had happened. A lawsuit built on a misread document, pressed forward by a man in financial distress, filed confidently against someone he had appraised as a retired old man with a pepper hobby and no fighting instinct. Every element of that appraisal had been wrong. In my professional life, I had written thousands of appraisals. The most dangerous error an appraiser makes is not overvaluing a property, it's undervaluing it. You can always negotiate down from a high number. But once you've told someone something isn't worth much, they make decisions based on that, and those decisions are very hard to reverse. Devin had undervalued me, thoroughly, confidently, and very early. Everything that followed was a consequence of that single error. A week after the TREC confirmation letter, my phone rang at 7 in the morning, a number I recognized. I answered. Silence for several seconds. Not a dropped call. The silence of someone who has composed what they want to say many times and is standing at the edge of it. Then Christine said, "Dad, I'm here." Another pause. I didn't know about the 1999 document, the satisfaction of debt. Her voice was careful, precise, the way it gets when she's saying something she's checked before committing to. Devin showed me the promissory note and told me the debt had never been settled. I believed him. I signed the affidavit because I believed him. "I know," I said. "How did you know I didn't know?" "Because you're not the kind of person who puts their name on a lie they know is a lie," I said. "You're the kind who puts their name on something they've been told is the truth." The line was quiet for a long moment. I listened to the silence on Christine's end, the particular quality of quiet that means a person is doing something difficult in their own mind. Then softer. "Dad, I didn't know." "I know," I said. I always knew. The TREC letter arrived on a Tuesday morning. Standard mail, no fanfare. I opened it at the kitchen table with my coffee and read it the way I read everything, carefully, front to back, looking for the sentence that actually mattered. It was on the second page. The Texas Real Estate Commission, following a review of 3 complaints against license holder Devin A. Howell, had determined that the evidence supported findings of violations under Texas Occupations Code. Section 1101.652, relating to failure to disclose material facts in real property transactions. The disciplinary action, suspension of license for 90 days, effective immediately upon receipt of the notice, plus a civil penalty of $9,500, payable within 30 days. I set the letter down, $9,500 and no license for 90 days. In real estate, 90 days without a license means every pending transaction freezes, every commission disappears, and some clients who get handed to a colleague don't come back. I did not feel triumphant reading that letter. What I felt was something quieter. The particular satisfaction of watching a thing resolve correctly, the way a properly written contract closes without ambiguity. Not pleasure at someone's pain, just the clean feeling of accurate outcome. I found out about Lubbock Realty Partners through Randall, who had kept a loose eye on developments after his contract ended. Devin's agency terminated his contract within a week of the TREC notice. Randall sent me 2 words. LRP, let him go. I filed the message and didn't respond. Craig Simmons filed his civil suit the same week. $47,000, principal plus interest accrued since the note's due date. The case was straightforward. A promissory note, a missed payment, a documented demand with no response. There was no clever argument available against it. The only question was whether Devon could settle, or whether it would proceed to judgment. Randall heard through the Lubbock professional network that Devon had listed a personal vehicle, a late-model truck, and was negotiating with his parents about moving to Dallas. The truck sold. Whether it covered the Simmons debt or went toward living expenses or legal fees from the lawsuit, I didn't know. I didn't ask. What I knew was this. A man who had arrived at Wallace Creek 8 months earlier with a practiced smile and a plan to extract over $1 million worth of land was now managing a suspended license, a civil judgment, and a professional reputation in Lubbock County that would require years to rebuild, if it could be rebuilt at all. He had read the first document and stopped. 3 weeks after the TREC letter, on a Saturday morning, Christine drove out to Wallace Creek alone. I heard her car on the gravel before I saw it, that particular crunch that I recognize the way you recognize any sound that's been part of your life for a long time. I was in the greenhouse checking the unnamed cross. The color had come in exactly right, deep red darkening to near black at the stem, consistent across the entire flat. 3 seasons of patient work. I met her at the porch. She was wearing old clothes, jeans, a flannel shirt I hadn't seen in years, and she was carrying nothing. Not a bag, not a document, not a reason. She looked at me for a moment and said, "I'm not here to ask for anything." "I know," I said. "Come in." We made coffee and sat without speaking for a few minutes, the way you can sit with someone when the silence doesn't need to be filled. Then I took her to the greenhouse and walked her through the rows the way I used to when she was small, naming each variety, letting her smell a Trinidad Moruga scorpion, leaf without touching it, which made her laugh for the first time in what felt like a long time. We didn't talk about Devon. We didn't talk about the lawsuit, or the affidavit, or the courthouse. There was time for those conversations, and they would come. But this wasn't the morning for them. This morning was for the greenhouse, and the peppers, and the particular kind of quiet that belongs to people who are finding their way back to each other carefully. After an hour, she sat on the old bench by the propagation table and looked at the flat of unnamed cross seedlings. Then she asked, "Could you have stopped all of this earlier?" I thought about that honestly. "Yes," I said. I could have shown Devon the satisfaction of debt the day I found the drawer moved. I could have ended it before it started. "Why didn't you?" I looked at the seedlings. "Because if I had," I said, "you would have believed him when he found another approach, and he would have found another approach. He needed to reach the end of his own plan before either of you could see it clearly." Christine was quiet for a long time. Then she said, "I should have looked more carefully at what I was signing." "Yes," I said, "you should have." She nodded, not defensive, not deflecting, just accepting it the way a person accepts something that is true. I had raised her to do that, and somewhere underneath everything that had happened, she still knew how. That evening she called Devon to tell him she wasn't coming to Dallas. I was in the other room and I didn't listen, but I heard the tone of her voice. Calm, flat, the tone of a decision that has already been made and doesn't require discussion. The call lasted 4 minutes. She stayed the night. The first time in 3 years she had slept under the roof of Wallace Creek, in the room that had always been hers, with the window that looks east toward the creek bed, that runs full 3 months out of the year. I sat on the porch after she went to bed. The night sky over West Texas is serious business, wide and dark and full. The ranch was quiet. The greenhouse lights were off. The barns stood where they had always stood. By December, the pieces had settled into their final positions. Devon was in Dallas. His TREC license had been suspended. The civil judgment from Craig Simmons entered against him for $47,000, plus accrued interest. His reputation in Lubbock County real estate was not something that could be repaired with a change of address. Christine filed for divorce in November. The papers went to a Dallas address. The revocable living trust for Wallace Creek was finalized with one amendment. Upon my death, the ranch passes to Christine Wallace, sole beneficiary, with the condition that no transfer to any third party may occur without the written approval of an independent trustee named in the document. I had chosen that language carefully. Dexter had approved it without comment, which from him was the highest form of praise. The Saturday before the Avenue Q Farmers Market closed for the season, I bottled the last run of Hellfire Herbert's Scorpion Reserve, 48 bottles, $14 each, sold out before noon. $672 in the box, which I put in the ranch account under operating income, because that is what it was. That evening I sat on the porch and looked at 340 acres in the last of the winter light. The unnamed cross had been bottled, labeled, and set aside. I had decided on a name for it. I was going to call it Wallace Creek Reserve, because it had taken 3 years of patient work, and because it was sharper than anything that had come before it, and because it was still here. The ranch was still here. That was the whole story. If you liked this story, please like this video, subscribe to the channel, and share your impressions of this story in the comments. To listen to the next story, click on the box on the left. Thank you for watching.